Thank you, Chair and Senate Committee. My name is Belinda Kochanowska. I'm the Principal and Founder of Intrepidus Law, a private NDIS legal practice. I'm also the mother of an NDIS participant child who is autistic. Thank you for the invitation to provide evidence today. Intrepidus Law has a practice that focuses on appealing NDIA decisions at the Administrative Appeals Tribunal. Our clients are NDIS participants seeking external review of NDIA decisions on their supports and people seeking access to the scheme who have been denied access. Our clients are typically appealing large cuts to their plans by the agency. They seek our counsel and representation to achieve reasonable and necessary supports. The majority of our clients are people with extreme functional impairment who require high-intensity supports, sole occupancy, SDA, specialist disability accommodation, for example, with one-to-one ratio of supports 24/7 hours a day, sometimes 2-to-1 supports during the day. And that's to stay alive, to keep away from harm or to minimise risk to others. My experience in appealing plans for such participants has taught me that getting supports in a plan right requires a line item level of scrutiny that can often be a matter of life or death for my client, and is always about protecting human rights and dignity. The proposed whole of person bucket of money approach, which is to be calculated in a way we have not yet been informed of and based on assessments which have not yet been determined and which will not be appealable, is a recipe for disaster for people with extreme functional impairment, in particular the very people the scheme was created for. By the time a participant comes to my practice, they have already been through the bureaucratic attempt of pigeonholing them into a package. And those packages are increasingly 1-to-3 support ratios for people with extreme functional impairment who want and need to live alone with support. You and I are merely a stroke away from becoming a participant on the scheme. I would not want to live with 2 other strangers simply because I am disabled, and I would want complete control over who gets to touch and care for my disabled body. That is a basic dignity. Indeed, it is a basic human right. We cannot avoid the fact that there are people who must have individualised and tailored support funding. That necessarily requires a line item approach, applying the reasonable and necessary criteria to individual supports. People with disability must be considered as individuals with support needs unique to them. Indeed, what is reasonable and necessary for one person may not be for the next, and the scheme must respond to this in flexible and tailored ways, which are based in evidence. Section 31 of the current Act captures that spirit of the scheme, which I fear this bill is attempting to dissolve. Section 31 of the Act states that funding supports under a participant's plan should, at paragraph I, maximise the choice and independence of the participant, and at paragraph J, facilitate tailored and flexible responses to the individual goals and needs of the participant. My clients achieve just and redemptive outcomes with our legal representation at the Administrative Appeals Tribunal. Unfortunately, it is almost as though one is required to go to the Administrative Appeals Tribunal to achieve tailored and individualised supports that the scheme is simply not delivering at the moment. The proposed Section 10 directly threatens these principles even more. The proposed Section 10 change in definition of supports is essentially problematic and incompatible with the scheme delivering a tailored and individualised approach. Without the rules being provided, it's difficult to assess the extent of that incompatibility. Any revision of Section 10 must give effect to the Convention on Rights of Persons with Disability, as per Section 3 and 4 of the Act, and preserve the spirit of Section 31 in being tailored and individualised. The NDIS is an insurance scheme. It's an insurance scheme that is rooted in human rights, and this must be preserved. Indeed, Section 3 objects of the Act provide that the objects of the NDIS Act are to give effect to Australia's obligations under the Convention of the Rights of Persons with Disabilities. Another major concern is procedural fairness and appeal rights. It is of serious concern to Intrepidus law that appeal rights are not being offered to participants with respect to proposed needs assessments. For any citizen to not have the right to appeal a government decision, which so intimately impacts their life or indeed could threaten their life, is completely unacceptable. To not even be given a copy of the assessment which determines the quality of your life and whether you can achieve your goals is offensive. Procedural fairness and appeal rights must be provided to participants of the scheme. In particular, participants must have the right to request a replacement assessment and review an assessment report or decision, including being able to review parts of that assessment, be given a copy of the assessment, be able to see the results of the assessment upon request, be provided with the details and experience of the person who has made the assessment. What is their experience with respect to your disability? Have a say in the mode of assessment. This is of particular importance for participants who have trauma backgrounds. These assessments, if they're to be delivered, must be trauma-informed. Be able to review a decision whether the disability or early intervention requirements are met is a basic right that must be provided in any review of this Act. These rights are not important just from a procedural fairness perspective. It strikes at the heart of a serious relationship crisis the NDIA has with participants. Trust has been eroded and people are traumatised by their experience. In that context, to give the CEO godlike powers to make assessments without review rights does nothing to foster positive and collaborative lifelong relationships that people with disability have with the agency. Intrepidus law rejects the bill as presently drafted and questions the haste in which it has been delivered and presses for urgent attention and pressure to be applied to the states to first establish much needed foundational support as the priority to addressing scheme sustainability. The priority in foundational supports must be the capacity building of mainstream schools and childcare settings to include and support disabled children. Indeed, funding for such settings ought to be contingent upon meeting KPIs on the successful inclusion and support of disabled children being met. There is a particular focus on children in the scheme at the moment, and foundational supports must be established first before children are shifted into separate classes of participant. The rate of school refusal of autistic and other neurodivergent children is unacceptable and is driving up the support costs of the scheme, and more investment in schools and early childhood settings is required as a matter of urgency if we are serious about long-term sustainability of the scheme. The scheme was not meant for everyone with a disability. The scheme was meant for people with substantially reduced functional capacity. In my experience as an NDIS appeal lawyer and a mother of an NDIS participant child, the first step in addressing scheme sustainability is building the capacity of schools and childcare settings to not just support, capacity build and include the next generation of disabled Australians, but to capacity build able-bodied children to learn about disability and accept and include people with disability, to see them every day as valued members of our community and not merely a cost to be reduced. Thank you.
Thank you. Go to Sussex Street Community Law Service now.